This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why there is never, under a homeowner's insurance policy, coverage for an insured who does not reside in the dwelling, and why courts must enforce the insurance policy in a homeowner's policy as written, and why they understand that the term reside is not ambiguous. The plaintiffs appealed the dismissal of their suit against Farmers Automobile Insurance Association. The plaintiffs were insured by Farmers for a St. Joseph residence that the plaintiff, Judy, had inherited from her deceased brother. The plaintiffs filed a claim with the company following a fire that destroyed the residence. Farmers denied the claim as the plaintiffs were not occupying the property at the time of the fire and were therefore not covered under the terms of the policy. In Judy Dardar and Ivan Dardar versus Farmers and John Sticklen, a June 2, 2023 decision of the Court of Appeals of Illinois, the claim of the Dardars was resolved because before he died, David Jones, Judy's brother, purchased an insurance policy from Farmers through Sticklen for property and liability insurance coverage for his residence in Champaign County, Illinois. After David's death, Judy was appointed the legal independent representative of the estate. Farmers issued a homeowner's policy amending declarations which added the decedent's estate and Judy as additional insureds, as well as a non-occupancy permit endorsement. Once the estate was closed and the house was transferred to Judy, she began making renovations to the residence. The plaintiffs were undecided as to whether they were going to live in the house after the renovations were complete or sell it. Then on July 4, 2018, fireworks embers from an unidentified source caught the house on fire and it was destroyed. The plaintiffs never lived in or occupied the home. Judy had no knowledge that the policy was issued with the non-occupancy permit endorsement omitted. Farmers denied the claim on the basis that the policy covered their residence premises, which is defined as 1, the one-family dwelling where you reside, 2, the 2, 3, or 4-family dwelling where you reside in at least one of the units, or 3, that part of any other building in which you reside. Farmers determined that the plaintiffs did not reside at the St. Joseph property and therefore were not covered under the policy terms. Judy claimed that Sticklen failed to properly inform Farmers of her condition, and Farmers issued a new policy without the non-occupancy permit endorsement. The court found that based on the facts alleged, there was not a sufficient basis for a breach of contract claim against Farmers and granted Farmers' motion to dismiss. Based on the relevant facts, the plaintiffs could never plead that they ever resided on the St. Joseph property. The court analyzed the issues by looking to whether the trial court erred in granting Farmers' motion to dismiss the breach of contract claim. It found that a court must construe a policy of insurance as a whole and take into account the type of insurance purchase, the nature of the risks involved, and the overall purpose of the contract. Reside is not ambiguous as it is used in the policy contract language between Farmers and the plaintiffs. The record established that the plaintiffs never lived on the property, were not occupying it in any way, and had not decided whether they would move into the home once the renovations were done. The mere fact that because reside has more than one definition does not make it ambiguous, especially when, as here, there is no definition of the word that would apply to the plaintiffs. The Court of Appeal, like the trial court, concluded that the term reside as used in the Farmers' policy was not ambiguous. In my opinion, there is nothing secret or difficult to understand about a policy definition that provides, quote, one family dwelling where you reside, close quote, since the insured did not reside in the dwelling, ever, or even try, and never resided in the premises, the unambiguous requirement of coverage was not met. They could easily have acquired a fire insurance policy that insured the plaintiffs as a non-resident against the risk of loss of the house by fire. Instead, they acquired a homeowner's policy that required that they reside in the house. They did not, and they recovered nothing. Now, they still have a case against the agent who failed to get them the kind of coverage they needed, including a non-occupancy permit that they had the year before. But this case only dealt with the case against farmers whose policy was clear and unambiguous. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and gain access to the more than 4,500 blog posts. You can also subscribe to these videos on rumble.com and on youtube.com. And if you do, please click on the like button or on the thumbs up button at Rumble. And please tell your friends and colleagues so that they can also subscribe to the blog posts, to the videos. And also, if you would be interested in more detail on insurance and insurance coverage, consider subscribing to my Locals community or my Substack publications. Thank you for your attention.